They said, well, that's our policy. I said, you haven't been in the playoffs in 13 years. How could you possibly have a policy?
You ain't got none.
That was with the years of Baron Davis.
Okay.
They finally made the playoffs.
Right,
You know
right.
what? In my 13 years, how could you possibly have a policy? I love the Warriors, so I've always watched.
Yeah.
Ready?
Exactly.
And are we on here? No, I'm okay. Are we on there?
Not yet. Okay, you guys, we gotta behave. Yeah, because he's on camera.
On camera.
He's telling you.
Try to make sure I stay in the box.
Yeah, Munoz.
That is visual aid.
Visual aid,
Not
yeah.
called a box.
Well, guess what Kathleen said? Stand in the box.
Zone.
All right, ready? All right, let's get started. It's a little after 11. So we have a lot of items we're going to cover today. We're going to do you should have my little notes for what's called probate class, and then behind that is the probate purchase agreement. We only got about an hour, so I'm going to try to get through. On the probate purchase agreement, I am not going to hit every paragraph because the probate purchase agreement is very similar in a lot of ways to the RPA, the car contract. But where I am going to hit is where it's not similar. What's the difference, et cetera. But just what I want to talk about initially is this whole probate concept in general, because a lot of us are starting to get clients that are representing estates, okay? So typically a lot of our stuff is really not what you would call officially probate stuff. Most of the stuff that we deal with, we're dealing with estates that were held in trust. So you're not going to do a full-blown probate per se, okay? So if you have a trust and you're dealing with a client who's held property in trust and one or both of the trustors are now deceased and the successor trustee is going to be liquidating the estate, then typically they have full authority to take care of the estate. Now, if the property was not held in a trust or there was no will, etc., then typically what you're going to do is you're going to have to deal with an administrator. And an administrator is typically appointed by a court. So in that scenario, an attorney would be helping that estate get an administrator appointed by the court, and then the court would spell out what authority the administrator has. So if they give them full authority and say, well, we're going to do this under what's called the Independent Administration Act, then they get full authority generally, or at least have limited authority. If they have limited authority, then you're going to go back to the court for a court confirmation hearing on your sale, okay? So, typically for me, first thing I'll ask them is, hey, are you working with an attorney? And if they are, then that's great because you're going to end up being, communicating with that attorney. If they're not, you should highly recommend that they get an attorney to work with. Because this type of transaction and this type of law in a lot of ways is very procedural. If you do something wrong, you end up having to start all over. So for example, if publication of the sale was required and you didn't do it, you got to start all over. Your sale is now going to be voidable, and you end up having to start all over again. That happened to me many, many years ago. The attorney that I was working with wasn't a very good trust attorney, but this was the family attorney. They forgot to publish the sale in a newspaper, and so we couldn't close the escrow. We had to go back and wait for the publication to be completed. So make sure that if you're referring them to somebody, refer them to an attorney that does this type of law, because it's a real specialty.
What kind of attorney would that be?
You want like someone who is an estate attorney.
A state attorney?
Yeah, they're ones that do trusts and estates. Huh?
I have recommendations.
I have a recommendation also. If you need one,
Me too.
I can give you one, okay? The other thing you want to find out is, well, hey, you know what? Yes, I have an attorney. One of the key things here that we want to know is whether on this sale there's going to be a notice of proposed action that is required. You should focus on that terminology. Because even if it's in a trust, or even if you're dealing with the Independent Administration Act, if a notice, and it says, and they tell you, hey, my attorney tells me there's no court confirmation required, but I do have to do a notice of proposed action. With the notice of proposed action, this is a notice that goes out to the heirs and the beneficiaries of the estate. If one of them objects to the sale, you are going to be going to a court confirmation hearing. So it's very important to know whether your sale will be subject to a notice of proposed action. Always make sure you're working with the proper person. Am I dealing with a successor trustee? Am I dealing with co-trustees? So when you meet with those clients, you want to get a copy of the trust, because you're going to need it eventually anyways, but you need to know the line of succession as to who you're dealing with, okay? If that trust says it's, Bill and Georgia as co-trustees, then typically it's going to require that both parties sign because they're co-trustees. So you have to read the trust to see, do I need both signatures? What if Georgia said, look, I'm flattered, but I don't want to be involved. I don't want to be a trustee. You have to see what that trust says. What if one of the co-trustees says, I'm resigning? Does that allow the surviving co-trustee to then sign everything on their own? So these are some of the things you have to find out, and the only way you're going to find them out is by looking at the trust. You're not there to interpret it legally, but this trust is your roadmap to what can be done. If it's a successor trustee, then it's typically one signature, the successor trustee only. Now, I just closed an escrow here this last week where I had successor trustees, okay? We had a trustee, the original trustee, who actually, his wife had passed away, but the husband was still alive, so he wants to sell his house. So we're reading through the trust, but he's got Alzheimer's, okay? And so a doctor declared him to lack capacity. He's incompetent. He can't sign. So now it goes to the next successor trustee. The successor trustee didn't want to handle the deal. So the successor trustee ended up resigning. And when the successor trustee resigned and turned in a letter of resignation, it went to the next successor trustee. You have to have all that documentation. Otherwise, title will not be able to convey merchantable title. So you've got to have that paper trail to show I'm dealing with the right person. This is the person who's authorized to sign. Question?
Yeah, so that first successor trustee canceled,
He resigned.
resigned. So what if there was no one else under that person?
Good question. So what if there was nobody else as another successor trustee to take over? What would have happened? You'd have to go to court.
Go back to court.
You have to go to court and have the court name an administrator
Okay.
to handle that.
Say,
Okay?
what if there's no trust at all?
If there's no trust at all, the person dies without a will. Now you gotta still go to court. And that's where you would definitely get an attorney involved, because you're gonna go to court and petition the court to name an administrator to handle the sale of the assets and the liquidation of the estate. So you go get that.
Now, would the administrator be one of the family members? or-
Not necessarily. Would the administrator be one of the family members?
Or the court?
Not necessarily. It's court appointed. More than likely, it would be a family member. So, for example, my mother-in-law passed away 4 or 5 years ago without a will. Okay? So my wife talked to her brother, and the brother said, why don't you be the administrator? We still had to go petition the court, do the paperwork to have my wife named as administrator for her mom's estate. Okay? So we couldn't really do anything until she was named as the administrator. Okay? But then in that situation, it's a little bit different, because now assets can't be distributed right away. And I'll get to that. Okay?
How many days of publication should be there in the newspaper?
I think it's a minimum of 30 days. It might be a little bit longer, actually, for publication in the newspaper or the sale.
Minimum?
You're not going to be involved in that, and you shouldn't even be discussing that. Okay, that's what the attorney does.
Oh.
That's not us. We're not involved in doing the publication. That's a lawyer's job, not your job. Okay? All right. If you need court confirmation, how do you know when to set the date? And we'll get into this in the contract too, but you really don't want to ask for that date until all the contingencies have been removed. Okay? So if you have to go for a court confirmation hearing to confirm the sale, do not try to set the date until the buyer has removed all of their contingencies, which in turn means there's really not short escrows on these types of deals. Unless you have no notice of proposed action, et cetera, then yes, you can run a shorter escrow. But if you have the notice of proposed action, you really couldn't do a very short escrow, because the notice of proposed action you don't want to send out either until all the contingencies have been removed. There's no reason to have to incur lawyers' fees by sending out a notice of proposed action, and then all the heirs say, okay, and then the buyer backs out, and now you're on to another buyer, and then the whole new notice of proposed action has to go out again. Regardless of whether it was the same sales price, it's a new transaction. So sending out notices of proposed action and setting court confirmation hearings, wait until all the contingencies have been removed before you send those out. On a notice of proposed action, the heirs and beneficiaries have 15 days to respond. And basically those are like a passive removal. If they don't respond, it's approved. They've approved it. So if they stay silent, that means they've accepted the terms of the transaction. Okay? Now, the question will come up, what contract should I use? Even though I'm not going through a probate, technically, I'm dealing with a trust. I'm dealing with a trustee that's got full authority. Can I just use a regular RPA? And the answer is you could, but if there's a notice of proposed action that's required, then you got to put that in a counteroffer, and you got to spell everything out that's a result of that notice of proposed action. The nice thing about the probate purchase agreement is it has a box that you can check that says no court confirmation required. But within that paragraph, it also explains the whole thing about the notice of proposed action and the potential ramifications of a notice of proposed action. So for example, if a notice of proposed action is required and you were using, let's say, a regular RPA, and you didn't mention anything about the sale being subject to a notice of proposed action, and it was, and now all of a sudden one of the heirs objects, and now you're going to a court confirmation hearing and the buyer's saying, wait a minute, nobody else can buy this property. That's mine because this contract doesn't allow an out for the seller. You would have a major problem as an agent, because if you go to a court confirmation hearing, you're subject to overbid. You're subject to an overbid because that court confirmation hearing is going to be published. And somebody may show up at the courthouse to bid on that property. Granted, they have to go 5% plus $500 to bid. However, if you're in a really good appreciating market, somebody may show up there and say, I'm going to bid on that property. And your poor buyer's sitting in that courtroom thinking he's got the property, and they don't. They may lose it. And now there's going to be a lawsuit because there was no contingency in that agreement regarding the notice of proposed action. So that's why that's a very important question to ask. That's why I typically will still use a probate purchase agreement regardless.
Always.
Bill, on that court action, if somebody does overbid the price, does the buyer have a chance to come back and rebid?
Yeah. The buyer. The question is, if someone comes in and overbids, can the buyer? Yeah, it now becomes an auction. The judge is now running an auction, and it goes to the highest bidder. But now the buyer's thinking, okay, I just had to pay another 5% at a bare minimum plus $500 because the opening bid is 5% plus $500, and then after that it goes up whatever. But the opening bid over the contract price on a court confirmation hearing is 5% plus $500. Okay, Jackie?
The buyer should attend.
Absolutely. Should the buyer attend? Absolutely. The
With a
buyer should
checkbook.
attend. They should be there.
So if you have a trust, you're saying, even
I guess if you're dealing with successor trustees, there could still be a chance that you would have to have court confirmation? If they
So if you have a trust, could there still be a chance of having a court confirmation? If a notice of proposed action is required, the answer to the question is yes. Because if one of the heirs objects, you now have to go to a court confirmation hearing, and that also changes your closing date, because now the closing date changes from what's stated in the contract to 10 days after the court confirms the sale. Okay? So it changes the entire structure. Now, if there's no notice of proposed action, like the recent listing I had on Waycross, the father passed away, I'm dealing with the son, it was in a trust, talked to the attorney says, no notice of proposed action required here. I said, great. Then we don't have to worry about that. So no court confirmation required, no notice of proposed action, no subject to overbid. Then you don't have to worry about it. Then I can just spell it out the way I want to spell it out. Okay? And I could use a regular RPA, but what I have to let people know on the regular RPA is you're not getting an SPQ. Because a regular RPA calls for an SPQ, etc. But you got to do the ESD still. Okay? So, but technically in that situation, I could use either this probate purchase agreement, no court confirmation required, checking that box, or just go with a regular RPA. But when you have a notice of proposed action, my recommendation is use this. Otherwise, you literally have to take the language in the no court confirmation box and repurpose it in your RPA, or at least in a counteroffer. Okay? Jackie?
So no SPQ even if the administrator was living in your home?
Correct. The question is no SPQ even though the administrator is living in the home. From a statutory standpoint, that is exempt. The SPQ is exempt. Okay? And when you look at the probate purchase agreement, there isn't even a mention of an SPQ in there. Okay? But if an administrator or even a trustee is living in the home, by law, they still must disclose all material facts that they're aware of. Now, if you want to use those forms to make that disclosure, there's nothing that prohibits you from doing that. Or you can just make a disclosure on a sheet of paper. Okay? So on the court, so the exemptions that you have really are TDS, SPQ, closing. Always make sure you're allowing enough time to close this escrow based on the situation that you're aware of. Okay? So if you know going in that there's potentially a notice of proposed action and somebody writes you a 10-day escrow, all cash, you can't do it. You can't do it because there's a 15-day notice requirement just for the notice of proposed action. So the only way you can really do that is to know that I have no notice of proposed action that needs to go out. There's no court confirmation, there's nothing. Yeah, then you could do a faster escrow on that. Okay, Diana?
So if there's a successor trustee dealing with it, is there always going to be a notice of proposed action?
You have to ask the attorneys whether there's going to be one or not. Typically, a lot of times there is not. There is not. But in a successor, like this last one I just did with successor trustee, no notice of proposed action was required. Typically when that property is held in trust, many times it's not, but there are times that it is. And that's something that the lawyers will tell you. I can't tell you that.
Does that mean that chances are if they need that notice of proposed action, there's some disagreement between maybe some ultimate beneficiaries and the trustee?
Well, you won't know that going in, whether there's disagreements, but you will know going in when you're talking to the trustee who the problem child in the family is. Sometimes you'll have a problem child on one just getting it. Right now, I'm dealing with one in San Jose where there's going to be an argument as to who's going to be named administrator. I got two siblings that don't agree on who the administrator should be. So now we got to let the judge decide and let the judge pick because the guy died without a will. Most of the kids are picking their sister except for this one child. Except he should be it. So now we got to let the judge decide who the administrator is going to be, and obviously in this case there will probably be a notice of proposed action required here.
Yeah.
Ken.
What happens if there is a trust document and the property is not made a part of the trust document and the guidelines?
If the property is not made if the property is not in the trust, then the man died without that asset being in the trust, you still have to get an administrator named. Okay? Yeah, because it's not part of that trust.
What
Not
is
in
the
estate.
different responsibilities between an administrator and the other trustees? Because everybody has to sign.
Different responsibilities between administrator and trustee, they're not different. They're not different. The only thing about the trustee, they've been named. They already were selected
In the trust.
in that trust.
They will have to
They're,
sign.
when you're an administrator, there's no trust. Typically, there's no trust.
Trust, okay.
Or at least there's not a successor trustee in line to handle it.
If you have a trust, do you still need a will?
If you have a trust, you still need a will. Every trust typically has what's called a pour-over will. So there's a will that goes with it, and the will, the reason why they call it a pour-over will is everything in the will pours over into the trust. So pretty much every trust has a will, but not every will has a trust.
Right, that's what I was gonna ask, if it's
Okay?
not, if it
It
doesn't.
can be in a will, but it may not be in a trust. And
Right.
when you're dealing with a will, you're not dealing with a trustee, you're now dealing with an executor.
Okay,
Person's got the same powers, but typically with a will, you will need a court confirmation hearing. That's one of the differences between wills and trusts. A judge will still need to sign off on that sale, even though there's a will that spells out who the executor is, what's going to happen, etc. But on a will, the court's going to be involved. And so when the court gets involved in that scenario, you'll see in the probate purchase agreement, now sales price becomes an issue because there's what's called a probate referee. Okay, and you have to sell the property within 90% of the probate referee's value. So let's get into the probate purchase agreement. I'm skipping over the agency and other stuff, okay?
okay.
And like I said, I'm not going to go through every paragraph. Let's go to D, the close of escrow. Again, what I was talking about before, as you see there, you can have a close of escrow, but if you have a court confirmation hearing required under paragraph 1D, then you know the escrow is not going to close it'll close within 10 days or whatever you put in there, but 10 days is going to be the minimum. Whatever you put in there from receipt of the court order confirming the sale. Okay? Now, let's jump to number 3, finance terms. In a probate purchase agreement, the default is no loan contingency. Even if you have a loan, you write in all these numbers on page 1 showing there's a loan. Okay?
Yep.
But until you get to page 2 where you check the box that says loan contingency, you don't have it. And that is critical. Let's jump to page 2. Now, at the very top where it says E, loan terms, loan contingency, applies only if checked. So let's say you wrote the offer, and you wrote it with financing in there, but you forgot to check this box. You've now written an offer that your buyer's getting a loan on, but you have no loan contingency. And if the loan were to be denied, that's not a way out for you. So if you've got a loan, make sure you check that box. Because otherwise, you don't have a loan contingency, regardless of the fact that you filled in the numbers on the financing provision on page 1. Understand that?
Is it the number of days down here?
Don't matter. If you don't check that box, that paragraph is out. It doesn't even apply. And that's actually what it says on page 1. It says, obtaining the loans below is, and in bold letters, not a contingency of this agreement unless paragraph 3E1, and that's in bold, is checked. If buyer does not obtain the loans, and as a result buyer does not purchase the property, seller may be entitled to buyer's deposit or other legal remedies. And what you're going to notice in a probate purchase agreement, there's no liquidated damages provision either, which means you're open to actual damages. Could be even more than the deposit that's in there. Okay, that is one of the differences in the probate purchase agreement. All right? Now, you jump down to paragraph number 4. Again, I'm not going through everything here. And it talks about the determination of the type of probate and court confirmation. And here is where you, under 4B, have to figure out, do I need court confirmation, do I not? If it's in a trust, you're not going to need it. You will check the box, no court confirmation required. But when you look at that, court confirmation of sale may not be required, subject to notice of the terms of the sale to beneficiaries or heirs. That's your notice of proposed action. If a beneficiary or heir objects to the terms of the sale, court confirmation of sale shall be required. Then you see paragraph 5 for the terms of that. Buyer shall have 3 days after receipt of the notification of a beneficiary or heir's objection to elect to cancel this agreement. So if now all of a sudden the buyer finds out, you have to disclose to the buyer, hey, one of the heirs has objected to the sale, I'm notifying you. Now the buyer has an out. You can say, look, I didn't bargain for a court confirmation hearing. I don't want to go there. I don't want to be subject to a potential overbid. They now have the right to cancel, and they get all their money back. They get their deposit back. So if that scenario ends up changing, then that's what happens. Okay? When court confirmation is required under paragraph 5, the seller shall file a petition to confirm the sale of the property with the court. The seller shall notify the buyer in writing of the court confirmation hearing, date, time, and location at least 15 days prior to the court confirmation hearing date. Broker strongly recommends that buyer personally appear at the court confirmation hearing to protect buyer's position in the event of overbidding. All right? So, you're now notified that, hey, we have to go to the court confirmation hearing. You need to give them a 15-day notice of the hearing date. Okay? That's different than the 3-day notice of, hey, we're going to this hearing. Now you get the hearing date, you must give the buyer a minimum of 15 days to notice of when that date is, date and time.
So
Okay?
buyers only or the agents can also go?
The agents are going to go also. If you're an agent, you're going to go too, especially if you're representing the buyer. Okay? Now, I've only had this happen once. In all the years I've been doing a lot of probate, I had the buyer on this deal. We had a court confirmation hearing. Actually, I had both ends. I had the seller and the buyer on this deal. And sure enough, the night before the hearing, I get a call from a prospective buyer who says, I'm showing up at the hearing. I may want to buy the property. I need you to bring me all the reports to the hearing. I want to review them. So I had to notify the judge, hey, I have a potential person here. They put me a little lower on the calendar. He went into the jury room, because there was no jury for that, and started reading through all the reports to see if he was going to make a bid on the property. He came out later and said, I'm not going to bid, and he left the courtroom, and I told the judge, there's nobody else here. Can we get on with the court confirmation hearing, which we did. But that's the only time in all the years I've been doing this, that happened. And that's actually the only time I've ever had to even do, actually I've tried 2 court confirmation hearings. Most of the time, like I said, you're dealing with trusts, you're dealing under the Independent Administration Act, and you don't have a court confirmation hearing. Some of the notices of proposed action have been complicated. I had one a few years ago where the trustee actually wanted to buy the property. And I had 7 heirs. And some of them were overseas. And that's kind of a conflict of interest. So my attorney and I worked together to notify all of them that, hey, the trustee wants to buy it. They're willing to pay, fair market value, et cetera, et cetera, et cetera. Had to get every single one of the beneficiaries to sign off to allow the trustee to buy the property. All right. So if you go to the next page, under B, the very top, California Probate Code may require legal notice to be published in a local newspaper advertising the sale of the property. If publication is required, buyer understands that seller is unable to accept buyer's offer until after the expiration of the period set forth in the published notice. In such case, acceptance of this offer prior to publication is voidable. Typically, you won't get the publication until after a contract has been accepted. But you see here that the buyer now understands that's a voidable sale. You may have a contract, but if somebody else comes in under that publication is going to bid, your contract can be canceled. Your contract can be canceled. Okay? And that's why it's important to use, in my opinion, this form, because once that whole thing starts, that court confirmation process starts, everything, the whole dynamic changes. Like I said, even though it's not really like a probate per se, this is what protects you. This contract's got the verbiage.
Bill, a quick question on your last one. You said, maybe sold to the trustee, at fair market value. What did you say fair market value?
Well, that trustee couldn't try to steal the property.
Right, but they require an appraisal?
Yeah, oh yeah, you gotta have an appraisal. I had my stuff, I had my paperwork turned in, and said, we gotta get an appraisal. Matter of fact, I think on that one, we got 2. Yeah, just to make sure that the estate was being, taken care of.
Did you pay for that?
I didn't pay for it,
Right.
but, you know, the buyer had to pay for it. Yeah, the buyer paid for it. So, and what a lot of times you can do in that scenario too is, if that's what was gonna happen, we never even hit the market with that property. My recommendation, and the trustee's a good friend of mine, but my recommendation is, well, why don't we just give you a first right of refusal? That way, we've been on the market, we know what the best offer is gonna be, and you can match it. But she had a good relationship with the probate attorney and asked the question, the probate attorney said, if you can get all the beneficiaries to sign off on the appraised value, there's nothing we can do about it. They've all signed off. So, and they were elderly, they didn't care. So, but yes, I mean, to my take was, hey, do first right of refusal, you know, so we go on the market, then I know, exactly, then I know. So if the sale's not confirmed due to an overbid, you know, the buyer will get their money back. Now, when you look at C, it says the purchase price offered, and this is typically, again, this is in a court confirmation setting, purchase price offered must be at least 90% of the probate referee's appraised or reappraised value of the property unless exempt. Well, typically an exempt transaction will be a trust, okay? But if you're not dealing with that scenario, and the court has sent out what they call a probate referee, and what's really sad about the probate referee, they put a value on the home and never even see it. They do a drive-by. They only do a drive-by. They don't go in the house and do a full-blown appraisal. It's just a drive-by. So I ran across an issue many years ago on this situation on a listing I had in Livermore, in Sunset East. The probate referee put the wrong, you were involved with that one. It was Jim and I. Put the wrong value on the house. You know? And here I'm stuck with this listing. I can't get rid of it. Chapin wants to write on it. He's bringing me this offer. I said, you're below the probate referee's number. You got 10% margin, but that offer was even below that. I had to wait, what was it, 4 months? Yeah, it was a long time. I had to wait 4 months so that I could go back to the court, petition the court to have the probate referee reappraise the house. Once they reappraised the house, Jim's offer fell within the 90%, and we were able to close that deal.
Why 4 months?
So, because they wanted enough market time on that property to say, okay, you're right. You've been out there for 4 months on the market. It's not going to work. You're not getting the offers. It's too high. But that's how long it took for us to petition the court to have them redo it and reappraise it.
There was only one offer?
So Jim's offer was the only one I had. But at the outset, it fell below the 90%. His people didn't want to come up. I didn't blame him. So, hey, just hang out and let me get it reappraised. So that's what we did, and then Jim sold it. No, once the probate, remember, the probate referee works for the court. So once the probate referee sets the value, that's it. So the court wants a certain amount of time for that value, and then after that, now I had more latitude. Actually, I turned in it was my value. I said, here's where I think it should be, Judge. You know, and I gave that to the administrator of the estate. Okay, under D, seller may remove the property from the court calendar if buyer has not removed all contingencies or only those contingencies checked below, at least 10 days prior to the court confirmation hearing. Note, local probate court rules may require that all contingencies be removed before a petition for confirmation can be filed. So, that's why I was telling you, don't go out and file. That stuff costs money. And it makes you look bad. Because every time you have to contact the attorney, or the attorney's doing some work on behalf of the estate, the bill for the estate just went up. So if you went and said, hey, look, you know, I know the courts on these cases only hear them once or twice a month. It's typically on a Friday, it may be a Friday morning, and courts generally only hear these cases once or twice a month, and their docket is generally full. So sometimes there can be a 60 to 90 day backup on this. And so you're thinking, well, man, I don't want to get way out ahead of this thing. Let's get the court confirmation hearing set, because I could be 60 days out on that. The problem is, okay, that costs money to file the paperwork, and now the buyer backs out. And now you have nothing. And so you got to pull that deal, because you don't know when the next deal may be coming in, and it's going to be a different deal. So now you got to pull that and get ready for the next one. Just wait. Just wait. Wait till all the contingencies are removed.
What happens if you're the buyer's agent and the listing agents set up the court confirmation hearing? I'm looking at one now. They put on the MLS, looks like they've already set the court confirmation hearing.
That's on them. What happens if the listing agent already set the court confirmation hearing and you're the buyer's agent? That's on them. You still write your contract the way you want to write. Now, they're probably going to counter you to try to squeeze you into making sure all your contingencies are hopefully going to be removed by that court confirmation date. But if it's coming up soon, it ain't going to fly. Because even if the court, let's use Vienna's example, even if the court confirmed the sale, it has nothing to do with the buyer's contingency periods. If my buyer's got rights for contingency removals after the court confirmation hearing, my buyer can cancel. And now that court confirmation hearing was pointless. Was pointless. Okay?
So no harm to the buyer.
There's no harm to the buyer, none whatsoever. Okay? All right, let's skip ahead. Probably way ahead. Let's go to paragraph 12, page 5. Statutory and other disclosures. So on the statutory, on a probate or on a liquidation estate, no TDS, no SPQ, okay? And if you look at when we get back to the exemptions, it will tell you that even the NHD is exempt. But the problem is that you're not exempt from disclosing whether you're in an earthquake zone, flood zone, etc. So it's kind of contradictory in the fact that, okay, I don't need a formal NHD, but I have to make the disclosure as to whether I'm in one of those zones or not. So why not just pay for the NHD and get it? It's the same thing when we get back there with smoke detector. There's no requirement for the smoke detector statement of compliance. It's exempt. However, there is a requirement under California state law that the house have a smoke detector. So that's not exempt. The only thing that's really exempt is the statement of compliance. So, okay, how do we know it has the smoke detector? So that's why we as a company on these deals ask you, we still make the NHD required and the smoke detector statement of compliance required, because a house still has to have a smoke detector, regardless of the probate status and the estate status. Even without the SPQ, you still need the ESD, the exempt seller disclosure, because if there was a death there within the last 3 years, you'd still have to disclose that. So that top portion of the SPQ is not exempt. And if you look under paragraph 12 where it says, however, talking about in bold letters, a subsequent or amended disclosure shall not be required for conditions and material inaccuracies of which buyer is otherwise aware or which are disclosed in reports provided to or obtained by buyer or ordered and paid for by buyer. So again, this is one of those items where, look, maybe the trustee who was living at the property forgot to include something on their disclosure, but in a report it was mentioned, then it's disclosed. It's no different than our other purchase agreement in that case. Again, you're selling the property as is, okay? Under paragraph 13, it's still an as is sale. All right? Let me see. Let's go to paragraph 22 on page 8, representative capacity. So now you're dealing potentially with a trustee. You'll want to get the representative capacity form signed that CAR has, because that makes it a little bit easier for signatures. So once you have that, so let's say you were dealing with either a trustee, an administrator, a power of attorney, etc., and you have them sign that representative form, and you attach the supporting document, the power of attorney, the trust, the court order making the administrator, Now when they sign their documents, they can just sign it the way they normally do, not like by so-and-so attorney in fact. Because that document helps them there. Now, with that being said, though, when they go to title to sign the closing papers, they have to still sign, if it's a power of attorney, attorney in fact, successor trustee, whatever. Title isn't going to recognize that document for the closing papers. They're still going to want it signed properly. If you're dealing with a trust, and let's take a scenario where the seller, like my last seller, was actually alive but incompetent. And what if the estate had decided, well, you know, he's incompetent, but for now, we're just going to do a power of attorney instead of doing this whole having to go through and getting a doctor's note, etc. Or before he's declared incompetent, you know, I'm going to have him sign a power of attorney. You have to make sure that the trust allows for a power of attorney, because many trusts do not. So let's say my client was actually competent, didn't lack capacity, but I'm old. I don't feel like going through this stuff. I don't feel like doing the paperwork, etc. I would much rather just have my son or my daughter-in-law sign for me. Okay, at that point, what they would need to do is he would need to resign as trustee, because he doesn't lack capacity. He can make a conscious decision to say, I'm resigning my position as a trustee, and now it goes to the next successor, because he can't do a power of attorney. And the other thing about powers of attorney is that if that person were to die, the power of attorney dies with the person. Okay? So it's always safer, especially when you're dealing with a trust, to just say, hey, why don't you just resign? And let's turn it over to the successor trustee, because even if the trust allowed for a power of attorney and you die, then your power of attorney is gone. Okay? It's not even valid anymore. And and God forbid, let's look at this terrible scenario. The power of attorney and the successor trustee are two different people. So you got one person who signed for him as a power of attorney, and now when he dies, he didn't pick his successor trustee as the attorney in fact. And now the successor trustee is going to be signing the rest of the documents. So if you are going to do a power of attorney, pick your successor trustee as a power of attorney, because there will be some consistency there. Steve?
So the big difference here is that you can get a power of attorney without going to an attorney. But to change your trust, to resign, don't you have to go back to your estate?
Good question. Steve's question is, the big difference is on a power of attorney, you don't need to go to an attorney to get it. On a changing of the successor trustee, don't you need to go to the attorney? The answer is no. No. Here's what you do need, though. You would need them to resign, and you would want the resignation papers signed and notarized. Signed and notarized. You don't have to go to an attorney to have the trustee resign. They can do a simple resignation, have it signed and notarized, and that's good enough. Okay? And, quite frankly, a power of attorney has to be signed and notarized too. So, either way, you're going to have that document signed and notarized. You can have an attorney draft it, but it doesn't require an attorney to draft it. It just needs to be signed and notarized. Ken?
With all these complications, is it real? What to do with it?
Is it what?
What to do with it?
Ken says, with all these complications, is it worth doing the transaction? Absolutely. Because these scenarios, you'll already know in advance how it's going to play out. I'm giving you multiple scenarios that can happen. You're only going to have probably one scenario you're going to have to deal with. You probably won't have to deal. Now, my last transaction that we closed, I had a couple of them come up, because I did have a living trustee. Now, with a living trustee, was I exempt from the TDS and SPQ requirements? No. No. Even though my owner resigned, he still had to complete the disclosures. He wasn't dead. This was not an exempt transaction. So he completed them actually pretty well. He was pretty aware. I was kind of surprised that the doctors said he lacked capacity, because when I met with him to take the listing, and I asked him for a social security number, he rattled it off right away. So a guy with Alzheimer's should know that, or probably wouldn't know that. But we went through, I asked him a number of questions, but by the time the transaction progressed, his condition was getting worse. Okay, his condition was getting worse. All right? But in that scenario, we had to do all the full-blown set of disclosures. He was still alive, he was an owner, so this was not liquidation of an estate by a trustee, by a successor trustee. Okay?
I have an idea.
Yeah.
But does that be being legally incompetent? Because at some point, you shouldn't be filling out disclosures if he's alive.
At that point in time, when we did the disclosure, I took the listing, there was no doctor declaring him lacking capacity.
So, but if he's alive and he's been declared,
If he's been declared where he has a lack of capacity. So when you look in the trust will tell you who's authorized to say he lacks capacity. It's usually a physician. Could be more than one. In this case, his trust only required one. Only required one physician to say he lacks capacity. And actually, it was his own personal physician. Okay? Let's jump ahead to the probate advisory. Okay? That's almost your last page. Okay? Second to last page. So now you start looking at the exemptions. What's exempt? TDS, NHD, Mello-Roos. Seller exempt is exempt from providing buyer the real estate, the TDS, the NHD, and the Mello-Roos district lien disclosure, etc. Earthquake guides, exempt. Smoke detector. The sale is exempt from state requirements that for single-family residences, operable smoke detectors be in place and that a written statement of compliance be provided to the buyer. It's the statement of compliance that's exempt. It's not the smoke detector.
Right.
You must still have a smoke detector in the house by California law. You just don't have to have a statement of compliance here. For us, you might as well just get it. Because how do we know? Okay, how do we know? And to get that document signed is very, very trivial compared to a potential fire in the house where nobody ever really verified that a smoke detector was there. Unless you had a home inspection that said, hey, there's an operable smoke detector there. Okay?
Upper water conservation and monoxide, carbon monoxide.
No. Well, let's get to that. Disclosures. Seller is not exempt from common law and statutory duties concerning fraud and deceit, even though a specific TDS form is not required to be completed. Seller remains obligated to disclose known material facts affecting the value and desirability of the property. So in the last scenario I gave you, my seller is still alive, but let's say you're dealing again with a trustee or administrator. Now here's going to be a question that you're going to come across. I'm dealing with a successor trustee who doesn't live in the property, but his brother does. Do I have to go to the brother and have the brother fill out, tell me all the material problems with the property? Since that's my brother. No. My brother has no authority to sign anything here. I'm the one signing. I am now technically the seller. So if I know something, I have to disclose it. Now, if my brother is constantly calling me up,
Telling
me stuff about the property, hey, he's, you know the scenario. He's living there for free, but he wants me as the administrator or trustee of the estate to keep fixing things for him, and I do, like my plumbing's backed up, then yep, I gotta disclose that. I'm aware of it.
Can you tell him, don't call me anymore?
Then you tell him, don't call me. Hey, don't call me. Block the call.
I'll send you.
Okay, hazard zones. The seller is not exempt from the applicable statutory obligation to disclose earthquake fault zones seismic hazard zone, state refinery. I mean, basically, they're not exempt from that, but they're exempt from the actual NHD package, so to speak. Just get it. Just get it. You're not going to want to put your trustee or an administrator in a position of being wrong about the earthquake fault zone. Just get it. Water heater, not exempt. Lead-based paint, not exempt. Carbon monoxide, not exempt. Okay? Database disclosure, Megan's Law, not exempt. Okay? Tax withholding, not exempt. So to me, I treat agent visual, not exempt. Agency, not exempt. All right, so there's very few exemptions. In my mind, the real exemptions are the TDS and the SPQ.
Yeah.
That's kind of your real exemptions. And that's only the statutory form that's exempt. The material disclosures are not exempt. Okay? I really want to kind of just jump down to the court confirmation and the independent authority, number 4. The representative of the decedent's estate may receive authority to sell the property under the Independent Administration of Estates Act. In order to do so, the representative must first petition the probate court. The petition may be made at the time the representative is approved or any other time. Notice of the petition is given to the heirs, devisees, and executors and other interested persons. So now we petition the court to have somebody named. Typically, this is going to be an administrator, and you're going to try to be named under the Independent Administration Act. If the IAEA authority is granted, it may be full or limited. If only limited authority has been granted, the sale must be confirmed by the court. Okay? You're really always going to go for full authority. If full authority has been granted, the representative must give a notice of the proposed sale to the devisees. That's the notice of proposed action. So if you're dealing with an Independent Administration Act, and even if you have full authority, you're going to have to give out that notice of proposed action. Okay? And that's where it tells you, if no objections received, the sale may proceed. This is the beauty of using this form. It spells everything out. So even when there's no court confirmation required, if like I said, you have a notice of proposed action, even when you're working under the Independent Administration Act and you have full authority, still use this form, because the buyer can never come back and say, I didn't know. It's right here in this contract. It's spelled out in this contract on more than one occasion. Okay, it's spelled out on more than one occasion. So that's the form that I would recommend you guys use. Okay? Questions? Huh? Makes a lot of sense. Makes a lot of sense.
I do have a question. Bill, many years ago, I represented a buyer on a probate where there was the proposed actions, and this is a couple of the young ladies, sisters, the parents have passed on. At any rate, the one young lady thought the house was worth $500,000 more than it actually sold for. And it was exciting and extremely informative to see the process that took place. What the listing agent had to do to verify the sale price, and what the young lady who thought it was underpriced and sold for underpriced had to prove her point. And these judges are tough, but the experience. But my question is, if I wanted to go back and rehash something that I experienced on a situation that we just discussed here, what's the best way for me to find the calendar and see where I can go to just sit in and listen?
Oh, if you want to go sit in and listen on one of these? Oh, you can just look it up. The court dockets are public. So you just find out which department is handling. Brian wants to know, how do you sit on one of these court hearings? You go down, you can call the courthouse and find out, like I said, in Fremont it's typically on Friday. Find out, hey, when are they hearing court confirmation hearings for probate? Where's the probate court located? And what's the hours that they're in session?
It's a neat experience.
And just go in there and sit in there. It's boring.
For me it was neat.
For me, it's boring.
What's our benefit?
The benefit to sit there, just to know the process and the procedure. That's really the only, to see how it works. I mean, you might get lucky and see if somebody's there to overbid.
Let people fight.
But, well, no, it becomes a little, the judge becomes an auctioneer. The judge now becomes an auctioneer. The judge is there on behalf of the estate. He wants to get the estate the most money possible, okay?
Like every other seller.
Now probate is turned over to Berkeley.
Is it Berkeley? Okay, well,
But,
no, I know there's
one in
local here
Oakland.
too.
There's one in
There is
Oakland.
Berkeley too.
There's
You're
one
right.
in
is
Oakland.
that like the trustee sales, where we're not, we cannot represent our buyer then, right, when the judge has an auction?
No, you're gonna still be there for your buyer.
Yeah,
The other thing that you gotta realize too, this is a little off subject, when you're dealing, let's say with the Independent Administration Act as opposed to a trust, you need to, this is the one that doesn't go over well. You need to let the heirs of the estate know you're not getting the money right away.
Yeah.
Because the money has to go into a special trust account where it has to be published for 90 days. At this deal closed, you got to do publication so creditors know there's money there. If the property were in trust, that doesn't happen. The heirs and beneficiaries can divide the money right away. But in a situation like Independent Administration Act, even with full authority, the money has to go into a special trust account, and then all the creditors of that estate have to turn their claims in within 90 days. The heirs might be able to get a few dollars, but not a lot. So the administrator now has to wait the 90 days before they can do the distribution to make sure there's no outstanding creditors that need to be paid.
But doesn't that 90 days occur no matter what, so they just kind of figure out what?
No, when you have a trust, they make a distribution. Oh, yeah, that's what I'm saying.
That's gonna happen if there's no money to sell or not. Those 90 days go out there and figure out.
Yeah, but what I'm saying is, when you're dealing with these folks, and you're sitting down with the administrator and say, oh, when we close escrow, what can I do with the money? Nothing. You're not getting it right away. As opposed to having that conversation with a successor trustee, because the property's held in trust, hey, what can I do with the money? You can do whatever you want. They're still obligated to pay, whatever the estate owes. However, there's no notice requirements. There's no notice to creditors that has to go out.
I was just going to say that what they recommend now, I just met with the bank manager yesterday about my trust to make sure everything's intact, and he recommends a separate account with your trustee's signature along with yours so they can have access to that money immediately,
Yeah.
like $5,000 or $10,000 or
Yeah,
something like that.
you can set up a separate account, but
Yeah.
when that escrow closes, it's going into that trust.
Yeah.
It's gonna go into
Yeah,
that
it's a
trust
special
account.
account.
Yeah. Okay, any other questions? All right, thanks, you guys, great.
Thanks.
That was good.
Thank you, Bill. Yeah, so We don't make any mistakes. you said if we go sit in a probate session to observe and learn, we might get lucky, that's what we
I'm talking about.
No, you're not there to pick up clients. You
Okay.
got better things. I said you might get lucky and see an objection, so you can see how the actual auction works. That's what I meant.
I just wanted to make that.
You're not going trolling for clients at the courthouse.
So Bill, I got a question. This is just general. So my mom had a trust. We sold her house before she passed. So do you still have that 90-day?
Oh, no, if you sold it before she passed,
Then it's not yet.
plus you have a trust anyway.
Yeah. And then there was no paying off of creditors either.
No, I mean, the creditors are still owed. But you don't have to do this publication. Wait for distribution. Your creditors are still going to come in.
Well, like I had taken care of all of her bills.
Right.
So she only had really one creditor, and that was Sears. So Sears
Contact
said,
them.
this is the balance on her account. Do you wish to pay it? And I was like, no. I said, it's okay. We'll have a good day. I wasn't on the account, so they couldn't force
Doesn't
me.
matter. If you're authorized to handle it,
Okay, cool.
Good answer.
The longer my attorney,
list it out.
You just like write it on a piece of paper.
Yeah, pretty much you say, hey, the seller or the trustee is disclosing the following material facts regarding the above property address and header. And just list out everything and have a sign it.
No official form.
No, you don't have to use an official form.
Okay.
It's something that you can
Quick,
First of all,
on a probate, there is the 90-day notice required.
I know
A probate.
Well, the notice for the 90-day notice has to be mostly, that's not part of our problem. That's a state issue. We don't care about that. I just want to sell the house. And the 90-day notice to creditors, you let the attorney.
Right, now, but that does apply for probate, because we're going back to my brother.
Oh, yeah.
Now, on this trust here, when does the 90-day apply in the trust? Or is it, okay, you said there's a 90-day notice for, after closed investment must be held in the trust account.
No, what's going to happen is, when you're having a probate, the 90-day notice is going out to potential creditors. And so that money needs to be held in that trust account.
Probate.
Yeah, and that probate account for that estate, that money's not being distributed.
Right.
Until the creditors have.
But it does not apply for the trust account.
No, when you're in it, now the property that was sold is in trust. You don't have to hold it, you can go into the trust account, and it can be moved right away. That's the difference.
Okay.
It was a good class.
Thank you.
Do you have a chance to go to one of those court deals?
I did a probate trust deal.
I tell you, when I was there, my representative fired, it was scary. For me, the first time.
Yeah.
And I tell you, and the agent representing the sellers, he had to, I mean, he was on the hot seat. He had to show the judge, approve to the judge, how long the house has been in the market.
Yeah.
What he did for marketing, days, marketing materials,
I had to do that.
offers used. I mean, bam, 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 bam.
Yeah, it's not fun.
Yeah, but it's interesting. That's like
It's
saying
very
it's informative.
interesting. No, it's worth being a part of or witnessing it at a courtroom or something like that because it is interesting. I mean, it's boring for him because he knows all about it, but
Yeah,
for us,
me, my eyes
Oh, yeah.
and ears are going, oh my God, oh my God.
Yeah, and I had to stand up in front of the judge and everything. I was like, what? You know, and answer questions. I was like, this is not what I'm used to.
I tell you, it makes you keep your ducks in line for
Yeah,
anything. You just
for
never
sure.
know. It's just,
I don't think I've ever documented a file as good
yeah.
as that one. You know.
Anyway, if I have a chance to do it again, when I think about it, I'll do it. Just the experience of the end.
Yeah, because then you'll know. You know.
Exactly right.
There's nothing like knowing.
You got a meeting you're going to attend, is that it?
Oh no, I'm done. I was at the first meeting, the second meeting, so I'm over for the day. It should be lunchtime.
I have breakfast for the Tim Henry.
Ah, yeah.
Yeah,
You eat breakfast every morning?
No. Yeah, that's why this is my first time in months. I don't need it.
I don't need it, but then I'm going to
Put
miss
that
it.
little bit, and then I have a sandwich.
Okay.
But not big.
Yeah.
But I eat more of it.
Too much.
It is for me, and I can't eat my baby fat if I keep feeding it.
Yeah, because when you get to a song
Yeah, it becomes a private conversation.
I just don't want to be on the screen with my
not
husband.
only financially, but my heart was. Yeah, so that was just such a piece before I could deal with it.
It's very difficult emotionally.
Yeah, so my daughter now is about it's just about something that you want to do. I don't even have a proper plan. I have a 5-year plan to do certain things. In place within this 5 years. Well, my mom died at 67. She died of cancer. I'm a Michigan. I'm a supervisor. And I plan to be one for the next 30 years. But
It depends. All up to the guy who's saying.
I feel I just